Supreme Court of India Sheikh Arif vs State of Maharashtra and another decided on January 30, 2024 SEC Online SC 85 Facts of the case. The allegation made by the second respondent is that an effort was made in the year 2011 by the appellant to maintain a physical relationship with her in the year 2012 by giving a false promise of marriage. The appellant had sexual intercourse with her on a number of occasions. In March 2013, the appellant took the second respondent to a hospital where abortion was done. The second respondent that in July 2017, there was an engagement between her and the appellant. Even after the engagement, the appellant continued to maintain a physical relationship with the second respondent. That on January 18, 2018, she saw photographs of the engagement ceremony of the appellant with another woman in his cell phone. The second respondent stated that a day before the date on which the complaint was filed, she was informed that the appellant had married another girl on 22 February 2018. FIR was registered against the appellant at the instance of the second respondent for the offenses punishable under sections 376, 2, 377, 504, 506 of IPC and various clauses of Section 3 of the Scheduled Castes and Scheduled Tribes, Prevention of Atrocities Act, 1989. Findings of the court. The question is whether a case for quashing the criminal proceeding is made out in view of the provisions of Section 375 of the IPC, if the victim of the alleged offense of rape is not under 18 years of age, maintaining a sexual relationship with her consent, is not an offense. The second respondent was admittedly more than 18 years old when the relationship commenced. When the complaint was filed, the age of the second respondent was 24 years, though she claimed that it was a forced relationship. She did not make any grievance about it till February 2018. In February 2013 and in December 2017, the second respondent was pregnant. It is not the case of the second respondent that from February 2013 to December 2017, the appellant forced the second respondent to maintain the physical relationship. In 2013, the relationship resulted in pregnancy. Still, it continued till 2017. In fact, according to the second respondent, in July 2017, there was an engagement ceremony between the appellant and the second respondent. Therefore, in the facts of the case, it is impossible to accept that the second respondent allowed the physical relationship to be maintained with her from 2013 to 2017 on the basis of a false promise to marry. If this material, which is a part of the investigation papers, is perused carefully, it is obvious that the physical relationship between the appellant and the second respondent was consensual, at least from 2013 to 2017. The fact that they were engaged was admitted by the second respondent. The fact that in 2011, the appellant proposed her and in 2017, there was engagement is accepted by the second respondent. In fact, she participated in the engagement ceremony without any protest. However, she has denied that her marriage was solemnized with the appellant. Taking the prosecution case as correct, it is not possible to accept that the second respondent maintained a physical relationship only because the appellant had given a promise of marriage. The continuation of the prosecution in the present case will be a gross abuse of the process of law. Therefore, no purpose will be served by continuing the prosecution. Appeal is allowed.